Hello again, guys. Back with the content for March 27 in Law 1204. And we're talking now about the context of professional liability. So this picks it up at slide 27 in the PowerPoint for today's content. The first slide in this area is a case from 1944 from actually England, but it stays very true to the applicability of professional liability here in Ontario and in many other common law jurisdictions. And so just the beginning of that quote captures what I wanted to highlight for you. And the quote says, "Before one can say that a man is carrying on a profession, one must see that he has some special skill or ability or some special qualification derived from training or experience." And that, in a nutshell, is exactly what takes us into the concept of professional liability. Some kind of competence that is required, that is expected from specialized training or professionalism or a skill set that one profession might have. So professional liability actions can be brought either in tort or contract if there's a contract, I should say, in place through which some professional liability was breached. So that would be at the direction of the practicing lawyer or paralegal. But of course, we're focusing on the tort component of that right now. The standard of care, the question that is asked, is that of the reasonably competent professional. So did this doctor act as a reasonably competent doctor? Did this lawyer act as a reasonably competent lawyer? Did the dentist act as a reasonably competent dentist? So that is the question that the court is asking. It raises that standard from the general duty of care from the reasonable person to the reasonable and competent professional, okay? On the slide, it suggests that there could be some room for movement, some areas for discretion. For example, it says, what about the local standards of care? There used to be this concept of a locality rule, the rural versus urban practitioner. And at one time, it was a factor that was considered by courts. So for example, does the doctor, are they held to a different standard if they're practicing in a small remote town as opposed to big city Toronto? At one point that was considered, only because it wasn't that the competence changed, but the extent of their knowledge or capacity might be slightly different because of things that they had at their disposal. That is very much not true these days, just because of the growth of technology and internet training, professional development seminars that go on that have wide access to both rural and urban areas. So that's largely not true, but to a certain extent, it could possibly play a role in differentiating between local standards of care, between an urban place or a rural place. The court has also at times made, a differentiation between negligence acts versus just an error in judgment. They've distinguished between these two. There are no clear factors how those two are identified as being separated, but essentially, if a court finds that it was just an error in judgment, then that means there was no negligence on behalf of the practitioner, and therefore no liability will be found. So just a couple of cases to highlight this point for you. I'm not talking about all of the ones that are covered on the slides, just I'm going to pull out one from each professionalism realm and focus on just the one of them. So one coming out of the workplace, a lawyer's workplace, is the Latta versus Linden case. It's an Ontario Superior Court decision from 2014, and it's about a failure to issue a claim. So Latta hired Linden as his lawyer to file a claim against his in-laws when he slipped and fell on their property, and he resulted in an injury to himself. And he was there while he was doing some work on their property for them. So he slipped and fell. He hired Linden, the lawyer, 2 years from the date of the accident. We know there's a general limitation period of 2 years. But this is just after the time that Latta had found out about the general limitation period. So basically he found out when it was about to expire, and he hired Linden immediately. Linden filed a notice of action, which is the first step that is required in a civil suit. If the statement of claim hasn't yet been drafted, it's to put the party on notice that a statement of claim is to come. The rules of civil procedure require that a statement of claim follows within 30 days. So that statement of claim was never sent or filed. Linden, the lawyer, just filed a notice of action. So Latta, he brings a claim or an application against Linden, claiming damages as a result of basically failure to issue the claim in the limitation period time frame. So basically he lost the limitation period, he's saying, and it's all Linden's fault. Linden very clearly in his defense that he was retained for a very restricted and specific purpose. So as you start to know a little bit more about working with lawyers and paralegals, lawyers and paralegals can draft a retainer, which is the contract with the client, for either broad terms or very narrow terms. Like a narrow retainer in this instance was probably going to be, I'm going to draft the notice of action for you, but nothing else. You need to take the further steps. So that's Linden's defense. He's saying, I only had a very narrow, restricted retainer with this individual. Furthermore, I didn't receive payment from the individual. And second, he told Latta, his client, that he was not continuing the work for him. So he had proof of those communications. Linden, then the lawyer, he brought a motion asking for summary judgment and to have the case dismissed. That motion was granted and the claim was dismissed. So we have talked about summary judgment a little bit in this case. So in this class, sorry. So in that circumstance, the Ontario Superior Court basically said this is not at all a situation of professional negligence. Professional negligence could certainly arise in an area where a statement of claim is not issued or filed on time, but they would have to be very different circumstances than what was proposed in this case by Latta. Sorry for keep touching on my screen there. I think my battery is about to die, so hopefully we can get through another couple of slides first. Another case I wanted to bring you to was faulty design case, in the area of architect law. And essentially, there's a numbered company, 792132. So all companies in Ontario, once they're registered, there's a number attached to them, and that's their legal corporate name. So you'll often find court cases filed with the number attached to it, okay? So the Ontario Corporation was the owner, developer, and general contractor of a project, which was a two-story high-rise building and a parking lot on top. Once it was completed by Ernest A. Cromarty, Inc., the rainwater caused the upper level parking structure to sag. So the numbered company, the Ontario Numbered Company, brought an action against the Ernest Cromarty architects for negligence. So essentially faulty design, okay? Or negligent design. The action was dismissed, which means the Ontario Numbered Company failed. The court found that the standard of care was that of an ordinary architect, and in fact the architect company had met that standard of care, or at least the Ontario Numbered Company could not show that the duty was breached in any way, okay? Costs were actually awarded against the numbered company in this case, to the tune of $94,000. So it's just another red flag that you're going to have to be careful if you want to bring a claim against someone. If the other party can prove that you brought them there and it wasted their time and the basis of their lawsuit did not amount to anything anyway, costs can actually be awarded against the plaintiff. So then the last case I want to talk to you about is in the area of veterinary law or veterinary professionalism standards, and this has to do with care and service. So the Willowdale Animal Hospital actually started this action by bringing a claim against the owner of a dog for failing to pay an invoice in their attempts to try and save the dog's life. So the claim amount was approximately $2,000. The owner of the dog said she should not have to pay because the treatment and the service was poor. Then there's some discussion in the case about how the dog was originally treated for anemia with blood transfusions, and then subsequent to that there was kidney failure and the dog died. So about within a week of the first treatment. The Court of Appeal split liability here. They said that the dog owner was in fact liable to pay the veterinary clinic a portion of the amount of the total claim against them, but they said the rest of the evidence that the owner presented in defense did not suggest negligence on behalf of the veterinarian in this case. So in all of those cases, there are examples of how professional liability was not found The defendants in those cases, or in the last case it was actually the plaintiff, but the professionals in those cases were not found to have acted negligently. There are certainly numerous examples out there, of course, where professionals have been found to act negligently. So the last slide I wanted to just bring to your attention in this area was that distinction between doctors and lawyers. General rules of professional negligence govern doctors and lawyers, but there are also additional rules that apply. So doctors are considered to have to be reasonably competent and can be sued for either failure to warn of potential risks associated with some kind of treatment or procedure. And they can also both be sued if the procedure itself was not competently performed, okay? Lawyers, the slide says they can raise or lower their standard of care by the retainer that's drafted. And this just really goes to the point I made a few minutes ago when I said the retainer, as long as it clearly outlines what is expected and it limits the retainer in some way to only one action that the lawyer is required to take on behalf of that case, well, that pretty much limits the duty that is required as well, right? So it limits the ability to for a client to sue for liability, to say, hang on a second, you didn't do what you said you were going to do. If the retainer says, I'm only going to do this much, like file the notice of action for you, then that's all I'm required to do, and therefore I have therefore acted as the professional lawyer in that case, competent lawyer in that case, all right? At one time, there was this concept of barrister's immunity, and it's the idea that lawyers could not be found negligent for their trial work because they didn't have control or capacity over dealing with the trial process and any things that might flow from that. And so the idea of barrister's immunity was that lawyers shouldn't have this hanging over their head that they could be sued for something along the lines of their trial process. That's no longer available in Canada as a defense for lawyers, just so you know. All right, and then that's it for professional liability. So there is one more area of law we need to talk about today, negligent misrepresentation, and we'll come back to that in another slide. Thanks for hanging in there. Talk soon.